Welcome back, everybody, to our study of the law of trusts. In this lesson, what we're going to do is talk about the concept of equity. This is going to be essentially the first three or four of these lessons on the subject of trusts. The first chapter of this major topic is, of course, looking at the idea of equity, looking at the historical development of equity, and then looking at some of the major maxims of equity. The aim here isn't for you to have a substantive, overarching understanding of equity in any particular great detail, but the aim is for you to understand equity to a good enough extent to then be able to transfer your understanding of equity to looking at equity's greatest invention, which is, of course, the nature of the trust. And then we'll start to talk about the trust in more detail, talk about the formation of the express trust, all the different kinds of formalities, constitution, etc., etc., etc. So, like I said, the previous lesson was an introduction to the subject of equity in trusts, talking about that subject in its general format. We noted that we're going to go through and spend a lot of our time in this series of lessons looking at the concept of the trust, because essentially this is a subject on law of trusts. This is a subject on trusts specifically, which is, of course, the most important invention out of equity. But is a way of getting some kind of foundational knowledge of equity in more detail. I'm going to spend time in this lesson, the next lesson, and the lesson after that talking about this particular concept. So we're going to ask the question more formally in this lesson: what actually is equity? Now, this is a question that we touched on briefly in the last lesson, and we examined in its general format in the last lesson. But we're going to go into a little bit more detail in this lesson, and then in the next few lessons we'll talk about how this concept began to emerge within the history of English law, talking about the development of and the rationale behind this idea of the Court of Chancery, the way in which the Court of Chancery would develop over time, the way in which the Court of Chancery in some cases would actually clash with the common law at instances. And there are notable examples during the early period of the Stuart dynasty where this happens. And then in the Victorian era, we see the fusion of law and equity with the Judicature Acts, the Supreme Court of Judicature, and the establishment of this merged system where you have both law and equity being adjudicated under the same jurisdiction. So the previous lesson, we had something of a definition of equity, noting that it was a concept which related to the idea of fairness, the idea of justice potentially, and so as a result of which we can have a basic understanding of what equity actually is. But it won't be until we've looked at these lessons in their entirety that we understand what actually equity is, because I can say equity is fairness, and equity relates to things pertaining to justice, for example, and we can talk about the theoretical approaches and the procedural approaches, which we will do in this lesson. But until we have an understanding of what equity actually involves and what equity has involved us understanding over the history of English law, we're not going to have the best definition or understanding, because we can essentially divide the subject of equity into two conceptualizations. We can talk about equity in the general by talking about the theoretical approach to equity. This includes examining things like the fundamental rationale and justifications for having the influence of equity within the common law. But there's also the legalistic approach, which is essentially how this applied to specific cases and the ways in which it would apply to specific cases. So when we look at the theoretical approach, we know, of course, that from the standpoint of theory, equity is a concept which does indeed relate to things pertaining to morality, to justice, and to fairness. According to Cohen, for example, the concept of equity is one which derives mainly out of the works and the ideas of the canon law, and the word itself, equity, comes out of the Latin equitas, the Roman law tradition, which was the sort of Latin conceptualization of justice, equality, symmetry, and fairness. So we see this transferal from the Roman law, civil law tradition of equitas into something of the religious canon law traditions, and then we see this develop into this concept of equity itself. It's a little bit messy how it all begins to amalgamate together and to form into into the concept that we know of today, and that's really more of a subject for a legal historian more than somebody who is studying the law of trusts. So we will not spend too much time doing that, looking for the origins of equity in either the canon law tradition or even within the Roman law tradition. When it comes to the legalistic approach to equity, the actual way in which it was applied on a case-by-case basis, we can look at the application in the procedure of legal systems. We will say that equity was essentially a body of law that would develop out of the English Court of Chancery. The reason why it became a body of law, almost its own separate jurisdiction, was because we see a shift away from the employees of the Chancellor to the application of judges within the Court of Chancery, and this sort of imbued equity with a certain amount of legalism, which essentially bogs equity in the Court of Chancery down to the same kind of critiques that equity was supposed to solve when we talk about the rigid, harsh nature of the common law. While equity exists in both the civil and the common law jurisdictions, if you remember back to that previous slide, equity derives out of the Roman law, the concept of aequitas, but it also derives out of the canon law, both of which were heavily influential in European legal systems. So it makes sense to suggest that it comes out of not just the common law in England and Wales, but also it comes out of the civil law traditions over in the continent. Under the common law, however, even though it derives out of or exists within both civil and common law jurisdictions, in the common law, equity did remain a separate and distinct jurisdiction until the Judicature Acts of 1873 and 1875. Now, the aim for the Court of Chancery and the aim of having a separate jurisdiction was to essentially make attempts to overcome the perceived inefficiencies of the common law, where the common law would be applied in the correct and ordinary way, but it was seen that the strict application of the common law leads to an injustice or an unfairness, then equity is said to be able to step in. And this all derives out of the monarchical authority that the king had to step into legal disputes and to utilize his power as the divine right of kings to make things right, to make changes to the particular decision of a case, to alter in a perceived manner to make a situation more fair or more just, to be able to deliver justice, essentially, which is one of the main aims of the monarchy. And so out of this concept, we then go from the king essentially delegating that authority to his chancellor, and then the chancellor ultimately delegating that authority to his chancery, and establishing eventually under the reign of King Edward III a formal place where the Court of Chancery would preside. We'll get to that in the next lesson. But one very useful definition of equity, or at least a definition of how equity operates in relation to the common law, comes out of the Dudley case of 1705, where they say that now equity is no part of the law but a moral virtue, which qualifies, moderates, and reforms the rigour, hardness, and edge of the law, and is a universal truth. Equity, therefore, does not destroy the law, nor create it, but assists it. This is a very nice definition, or at least a very nice description of what equity essentially does. It talks about it being something which it almost transcends legal values. It is something of a moral value, and what it does is it sees the law itself. It sees the decisions that have been handed down through the common law, sees the way the common law is quite harsh. It is quite rigid. It has got something of a sharp edge to it, if you will. And what it does is assist the common law in being able to deliver justice in the most appropriate way. It does not destroy the law, nor does it create the law, but instead it assists the law. So the issue, what we find ultimately with the development of equity and the Court of Chancery, is that as it begins to develop, it begins to essentially take on a role of its own as a distinct body of law and legal rules. So whereas equity was seen as a very flexible, almost precise tool for the application of rules to specific cases. One of the things that we're going to talk about in the next lesson and the lesson after that is this idea that equity acts in persona, one of the major maxims of equity, the idea that it is essentially applied to the personal characteristics of a particular case. And so as a result of which, that made it very flexible and very applicable to various different circumstances. But as it begins to develop into its own distinct body of law and legal rules, partially because of the influence of judges being part of the Court of Chancery, or beginning to be part of the Court of Chancery, you could argue that the Court of Chancery began to become impeded just in the same way that the common law was impeded, with quite strict adherence to legal principles. And it wouldn't be until we see the Supreme Court of Judicature that we see something of a fusion between these two rules. Now, there is still debate about whether or not fusion has actually happened, and this is something that we're not going to get into in this series of lessons, but the quote-unquote fusion debate around whether or not law and equity have actually officially fused together, or that they still remain distinct despite having the same jurisdictional, the same area of jurisdiction, is a debate that will continue to take place. In the previous lesson, we asked the question about what it actually is to describe something within equity. What actually is equity itself? And we came up with a number of different definitions, and we talked about the fact that equity was something of a historical development. Well, the historical development that we're going to examine is going to be explored in this lesson. We're going to talk about the history of equity in a relatively brief context. It's going to be as brief as possible, even though, of course, the history of equity and the history of the Court of Chancery is incredibly detailed and complex, but obviously would probably merit its own separate series of lessons. I would just like to add as well, by the way, that the process of researching this lesson and examining some of the historical context was incredibly fun. So I just want to put a little stamp on there about how much fun I had making this lesson. The previous lesson, I said examines the nature of and the definition of the concept of equity. And like I said, we're going to briefly examine the historical development, because of course it would merit a whole series of lessons itself in order to cover the history of the Court of Chancery in its substantive detail. So ultimately, we can understand where equity comes from by reference to the kind of legal system and adjudication which existed in the very earliest periods of English history and English law. So the nature of the structure, if you will, of the English legal system from this very, very early period gives rise to the suggestion that equity could be a useful contribution. So the way a claim, for example, would be brought about in this very early period within early medieval England was through a system of writs. Now, a writ is simply a formal order which is issued by some judicial or administrative body, and the system of writs, the royal writ itself, was a system which is limited in the sense that ultimately what you would have to do is bring a claim which corresponded to a particular writ. There were a number of different writs that had authority to remedy, and so as a result of which, if you had a claim that did not correspond to a particular writ, then you wouldn't have a remedy available to you for a particular case. And so as a result of which, the development of the early common law in this regard was particularly rigid and particularly difficult because of the fact that you had a very limited writ system, and then this writ system would actually become even more limited by some historical events which takes place in and around the 1250s. And this includes the provisions of Oxford. So, for those of you who have studied law or history, you'll be familiar with Magna Carta from 1215, but you might not be as familiar with the provisions of Oxford, because the provisions of Oxford were actually quite similar to that of Magna Carta. There were a number of constitutional changes which developed out of the Oxford Parliament of 1258. Now, the reason why I can make the comparison to Magna Carta is because they arose out of a similar kind of dispute. They arose out of a dispute between the king at the time, who was Henry III, and his barons. And what this meant was it acted in a similar way to Magna Carta, which of course was a dispute which gave rise to Magna Carta, which came out of a dispute between the king at the time, which was King John, and his barons. And so as a result of which, the provisions of Oxford did a thing that's useful for us, at least for our understanding, is that it limited the number of writs that can be issued by the king. And this is obviously problematic, owing to the fact that the already rigid system of the common law was beginning to struggle to be applicable in every single case and circumstance that was brought before it. It therefore meant that there would be more rigidity within the common law system, owing to the provisions of Oxford limiting the number of writs which could be issued by the king. Now, as a sort of brief historical aside, it was a symbolic indication that the common law was supreme to the whims of the monarch, so the monarch can just issue a new writ for any circumstance in that regard, but of course that had its own failings in the sense that it made the whole system of legal adjudication particularly rigid. So ultimately, we can see that the provisions of Oxford would be revoked as a result of the Second Barons' War between 1263 and 1267, but the thing that is important for us, again, is that even though the provisions of Oxford would ultimately be revoked when King Henry wins this Second Barons' War, the administrative changes that had been implemented from 1258 would remain pretty much the same, and then would ultimately be confirmed by a further piece of statute, which is the Statute of Marlborough from 1267. So at the end of the Second Barons' War, you get a revocation of the provisions of Oxford, but then you get the administrative changes that were already implemented being solidified by the Statute of Marlborough in 1267, the result of which is ultimately that the issuance of writs became another example of a rigid system of law. So when we have this common law jurisdiction becoming quite rigid and quite difficult to achieve justice in all circumstances and situations, the system of writs begins to show its clear downsides and its clear lack of ability to operate. And this is the sort of groundwork, the foundation, which leads to the establishment of a Court of Chancery. So in terms of what the Court of Chancery did in terms of legal changes, it did quite little. All it really did was formally establish a permanent place of location for the administration of justice. Because before the Court of Chancery, the king often enjoyed the discretion in the application of law to his subjects. He would often step in and make claims on the basis of justice and the deliverance of justice in a particular case, which ultimately was what the Court of Chancery existed to do. The Court of Chancery was simply the institutionalization of this process. We know that from the reign of King Edward I, that the duty to have this discretion in the administration of justice, in the application of particular cases, would ultimately be given from the king to the king's chancellor. This is owing to the fact that, of course, there were very many cases. The king was a very busy individual, and so as a result of which he would delegate this authority to his chancellor, who then in turn would delegate this authority to his staff, and created a fixed Court of Chancery in this regard, utilizing this kind of administrative authority of the king in the discretion and the application of law, and wielding this power that the king has in the application of justice through not only through the chancellor, but through the staff of the chancellor in the Court of Chancery. Evidence of the Chancellor, for example, of the Chancellor of Edward II, the monarch afterwards, from records of the Parliament of Lincoln in 1315, shows that the Chancellor would even delegate these issues to his personal staff. And this is really where we start to see the formation of a Court of Chancery. It wouldn't be, however, until Edward III that we see the formal fixed location of the Court of Chancery be established at Westminster Hall. Now, the reason for this, the reason for a fixed location of the Court of Chancery, was to firstly show and create the institutionalization of a court of equity, but also it made it easier for the subjects, for the king's subjects, because the Chancellor would historically have to travel around with the king, and so administration of justice meant that you had to go and find where the king was to have a case heard before it. Now you have a fixed Court of Chancery at Westminster Hall. You can go to Westminster Hall and have your case heard in that regard, rather than having to find where the king is. So this is where the Court of Chancery begins, and it stays and remains in Westminster Hall pretty much for the entirety of its period, to the point where it then gets abolished in the 1870s, which we'll get to in a second. But one of the things that's quite interesting here is that it is still something that is considered to have authority that stems from the power of the king. So the reason why we have a court of chancery at this point now is because the king would have the discretion historically to get involved in particular cases and to make decisions on the basis of a particular case, to essentially deliver justice for his subjects. This power that came out of the king was only delegated to his chancellor and to the Court of Chancery. So the power of the Court of Chancery still stems at this point from the king and the king's authority. It is only under the reign of Richard II that we start to see the Court of Chancery be understood not necessarily as a power that is deriving out of the king, but as a court that had this power in and of itself and was distinct from the king and the king's administration of justice. So one of the things that the Court of Chancery historically did, at least in the medieval and early modern period, was avoid conflicts which may arise between the common law and the court itself. So it did so by not denying the existence of the authority of the common law, but it rather acted in personam. Rather, it didn't exactly apply legal principles that the common law would apply, like the common law. It instead applied principles of equity to individuals and individual cases. This, of course, can be seen in the concept of the trust, the recognition of the legal owner of a particular property, of a trust being in the hands of the trustee, but of course the transference of legal ownership, where we have the Court of Chancery intervening. Obviously, they impose the importance of obligations in equity for the benefit of third parties. That is the whole nature of the trust solidified in this concept. The idea that you have a settler or a testator who hands this legal rights to a particular trustee, and that trustee holds that property on trust for the equitable fiduciary benefit of the beneficiaries of a trust. And so that's where we get an example of the relationship between law and equity. But the concept of equity in the Court of Chancery was very, very clear in that the applications of principles of equity acted in personam. They were acting on the basis of individual cases, not necessarily acting on the basis of applying law to facts per se. But this is not to suggest that there were never conflicts between the common law and the Chancellor and the Court of Chancery more generally. Under the reign of James I, for example, so we're skipping all the way to the period of 1603 to 1625, there was a conflict between the Lord Chancellor under James I, who was Lord Ellesmere, and Lord Justice Coke. Coke asserted that the Chancellor's issuance of injunctions were considered to be unlawful, and so essentially making the claim that the common law was clashing with the Court of Chancery. The two would attempt to challenge the decisions of each other in a number of different cases. So, for example, in the case of Courtenay and Glanville, they were both overseeing jurisdiction, with the Court of Chancery and Lord Ellesmere dictating that Glanville should be imprisoned, while Lord Justice Coke demanding that Glanville be released. A clear example of a conflict between the common law and the Court of Chancery. A similar thing took place when we look at the Earl of Oxford's case. And so what happened was the Court of Chancery, the Lord Chancellor himself, Lord Ellesmere, would appeal to the monarch to try and resolve this dispute. This dispute was then referred by James I to the Attorney General, who was Francis Bacon, and Francis Bacon favoured Lord Ellesmere's approach, essentially asserting in this regard the authority of the Court of Chancery over the common law, which is quite interesting. And then we can take our time to then come to the fusion of the Court of Chancery and the common law jurisdiction. We're taking a big jump, unfortunately. Like I said, this is a history video, but the history of this particular topic could be a series of lessons in and of itself. If we skip to the Victorian era now, for a start, we can see the popularity of fusing the common law and equity courts coming into fruition. So, for example, the Lord Chancellor, Lord Selsdon, would issue a bill in 1873 called the Supreme Court of Judicature Bill. A number of provisions would be amended as part of this Judicature Act, and it would ultimately become the 1875 Supreme Court of Judicature. At this point, the Court of Chancery ceased to exist. New courts would have been established that have dual jurisdiction. And so then we get the fusion of the two areas of law, to the point now where common law courts, the courts that exist in the judicial system today, the courts of appeal, etc., 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 could have the ability to apply principles of equity to the concepts that we have here. And so, as a result of which, the debate about fusion is often brought up about whether or not there really truly is a fusion of the common law and the courts of and the law of equity, or rather that they are still separate. You still apply the principles of equity separately to the principles of the common law, but they're just done by the same person. This is a debate that we're not going to have in this series of lessons, but it's a debate that is often had about the fusion of these two areas of adjudication. In this final lesson, looking at the concept of equity, what we're going to do in this video is specifically talk about the maxims of equity. Now, this isn't going to be something that is going to take much time, essentially, because what we're going to do is list the maxims of equity. I might pick out and highlight a few of the interesting ones, but for the most part, we're not going to go into an advanced detailed examination of each of them because there's not really necessity to do so. When a maxim of equity comes up in the subsequent lessons on the law of trusts, we will highlight them and we will talk about them in relation to the particular context of trusts that we are examining. Remember, this is a series of lessons on the law of trusts, not specifically on the law of equity. And so as a result of which, in looking at equity, it's important to be able to provide an introductory examination of this subject, but then to now move on to thinking about the concept of the trust in more detail. So we know already that the Court of Chancery developed over many centuries a distinct jurisdictional element of the law that we now call equity. And one of the guiding principles behind this idea of having this jurisdiction of equity was the establishment of a number of maxims, which were designed to offer some overarching guidance to judges, or at least to members of the Court of Chancery, when it comes to the administration of equitable jurisdiction. So these aren't necessarily strict adhered to rules, but they are characteristics of equity, if you will. They are the things that we can attribute to the concept of equity in our understanding of the subject. And so we can distill these into a series of maxims, which are then still applied in law to this day. And as an overview, the maxims of equity are as follows, and we'll talk about some of them in a bit more detail, but in their generality, we have a few. So we have, for example, the maxim that equity will not suffer a wrong to be without a remedy. Equity is equality. Delay defeats equity. He who seeks equity must do equity. He who comes to equity must do so with clean hands. Equity acts in personam. Equity will not perfect an imperfect gift. Equity follows the law. Equity regards that done which that ought to be done. Where the equities are equal, first in time prevails. There are others, of course, there are others that exist, and we will come and go when we look at the different kinds of maxims that exist. We would pick out a few of these ones as well. Some of them are quite easy to understand, really. So, for example, he who seeks equity must do equity simply means if you are looking for an equitable remedy, you must have acted equitably yourself, okay? But we will get to some in more detail. Let's think about this, the first one then. The idea that equity follows the law. What does this actually mean? Well, it simply tells us that unless there is a reason not to do so, equity will now follow the rules of the common law. So if a common law decision exists and is applied in a correct way, there must be a standard by which equity should contradict that particular common law rule. So it means that unless there is some reason to abandon a particular common law rule, equity will not contradict that said common law rule. Instead, it must essentially try to harmonize itself with the common law. So one of the things that is clearly a problem when we talk about the distinction between law and equity as separate jurisdictions is the idea that the two jurisdictions will clash. And we had conversations about this when we were looking at the history of equity, when we were looking at various clashes that existed between the Chancellor and the and Lord Justices, like Lord Justice Coke having some problems with the Chancellor in terms of determining the correct remedy and outcome of a particular case through the lens of either the common law or through the lens of equity. And so today, one of the maxims of equity tells us that instead of trying to act as a force against the common law, equity should harmonize itself with the common law, such that rather than trying to step in and contradict the common law, equity acts in a way which essentially smooths some of the rough edges of the common law jurisdiction. The second maxim, he who seeks equity must do equity. We mentioned this already, but simply an individual who is looking to seek some kind of relief out of equity, they themselves must act in a way which is fair towards the opposing party. They must be equitable in themselves in order to actually be able to seek some kind of relief. Those who seek equity must do equity. It seems to make sense. It doesn't seem to be much. It doesn't seem to be quite fair, shall we say, that if somebody seeks to have an equitable remedy implemented in their favour, they should be acting in a way that is equitable themselves, because otherwise then that is a particularly unjust application of the principles of equity. A good example of this is illustrated in the case of Chapel and Times newspapers, where it was illustrated that if an individual seeks to get an injunction for the specific performance of a contractual obligation, that individual themselves must also be willing to fulfill their own contractual obligations, because otherwise they would be achieving an unjust settlement in that particular example. Another important maxim is this idea of equity essentially being something which acts temporally. So where the equities are equal, the first in time prevails. Essentially it means that where there are two claims that are equitable claims that both have equal merit in their own right, in those circumstances, the individual or the organization or whoever who made that claim first will be the one that has priority over the other. Okay, simple as that. So where there is a clash in equitable claims, where equities are equal, the thing that delineates them is the time at which the claims were implemented or levied against the other. And so the result of which is that equity acts temporally. It acts and favors those who enter a claim first. Another very important maxim is the idea that equity will act in persona. The point behind this is to try and look at how equity applies to the individual specificities of each and every case. So we will see that in the types of remedies which are issued in equity, the idea is that we are not applying broad standards across consistencies of cases. We are applying specific minutiae against individuals in individual cases. We are looking at the facts of each of the cases themselves. We are acting in persona. And so a result of which is, if we look at some of the remedies, things like search orders or injunctions, they are very personal in terms of their application and specificities to individual cases.